All right, thank you so much, everybody, for being here today. It's been a great conference so far, and I'm very excited to introduce the next panel on in-house counsel. We're going to have 3 speakers on this panel. Immediately to my right is Sally Guns, who's a professor of business law and professional ethics in the School of Accounting and Finance at the University of Waterloo in Canada. Her primary research interests are the legal and ethical responsibilities of professionals, focusing on how professionals make ethical decisions and what factors influence those decisions. She's the author of The New Corporate Counsel and has started her career studying corporate counsel. At the moment, she's working on a large study looking at lawyers in large commercial practice and comparing key elements of the career structures of corporate counsel and private practice lawyers and how those relate to ethical decision making. In the middle, we have Paula Shafer, who is a professor of law at the University of Tennessee. Her scholarship focuses on issues of attorney ethics and fiduciary duty, and she's especially interested in exploring why attorneys sometimes unwittingly harm their own clients, and ways that courts, lawyers, and the law can influence attorneys to fulfill duties to clients. She's written a number of really excellent law review articles, and she's also my co-author on our PR casebook. Then on the far end, we have Jonathan Lycan, who is currently the Senior Vice President, Chief Legal Officer, and Corporate Secretary at Diebold Nixdorf. He oversees the organization's global legal function and corporate compliance program and serves as Corporate Secretary to the Board of Directors. He previously worked as a partner at Jones Day. And prior to that, he served as a federal prosecutor working as an assistant United States attorney in the criminal division of the U.S. Attorney's Office for the Southern District of New York. He is a Cleveland native and also teaches at our law school, and we are thrilled to have all 3 of you here today.
So I think it's starting with me, and I'm starting with a little clip.
Consider balanced, but there are some bad acts.
The media debate about the basic operating principles of the corporate world was quickly reduced to a game of follow the leader.
I still happen to think the United States is the greatest place in the world to invest. We have some shakeups that are going on because of a few bad apples.
Some people call me a bad apple. Well, I may be bruised, but I still taste sweet. Some people call me a bad apple, but I may be the sweetest apple on the tree.
These are not just a bunch of bad apples.
This is just a few bad apples.
It's not just a few bad apples.
We've got to get rid of the bad apples. You can start with Tyco.
Bad apples.
We know all about WorldCom.
Bad apples.
Xerox Corporation.
Bad apples.
Arthur Anderson.
Bad apples.
Enron, obviously.
Bad apples.
Kmart Corporation.
The fruit cart is getting a little more full.
I don't think it's just a few apples, unfortunately. I think this is the worst crisis of confidence in business.
Thank you. It's one of those clips that I love showing in class because is this on? A bit more towards me. Okay. The key theme, of course, is that it's really nice to blame anything bad that happens on the individual, with the result that if we only just got rid of that individual, all our problems are solved, and most importantly, we never have to address the fundamental problems that might have given rise to that problem, whatever the crisis is you're dealing with. Today, the theme I know that I'm going to be following, and Paula, who follows on from me, is that when we study ethical issues for in-house counsel, any professionals, any individuals at all, it's really important to examine the environment in which they're operating, because the world in which we all operate obviously influences us in many ways, and if we fail to understand that, we never come to grips with the fundamental issues that we're supposed to be addressing. So today I'm focusing obviously on in-house counsel because that's my job. But as I said, these issues apply across the board with professionals and individuals. And the ethical challenge is always very obvious. Whenever there's a corporate failure, whenever there's a corporate fraud, the first question that comes out of people's mouths is, where were the professionals? It's inevitable. Just follow it from now on. You'll see that question asked. And there's asked for very good reasons, and the reason is this. The average manager cannot do what they do, with the exception of they sneak in the back and steal from the piggy bank. They cannot do it without the assistance of professionals like lawyers and like accountants. They need the lawyers to do the papering, they need the accountants to do the numbers. They literally cannot do it without professionals. So that means whatever the crisis is we're currently examining, there have been professionals involved at some level participating, enabling in those actions. So it's fair game to say, where were the professionals? And the question then arises, is we're talking about people who are very well educated, highly trained, people like you who are trained by law schools, my students in accounting and finance, and we spend a lot of time educating people in ethics. Nonetheless, bad things clearly happen. I want to make clear from the beginning that my interest is never in the person who's actively bad. There are bad people in this world, and as a student, there are bad students. As professionals, there are bad professionals. My personal feeling is you can't do much in terms of changing those people. You just have to have really good control systems and try and catch them before they do anything bad. My interest is always in the vast majority of people who I firmly believe, being a Pollyanna, are good people, but somehow get involved in decision-making that is not good. So I want to begin with an observation that came from a lot of academics studying in the 80s and the 90s and following on, began the sort of discussion of problems in ethical decision-making for employed professionals with a notion called organizational professional conflicts. And I'll just very briefly explain what that was, because we all understand what professionals are. A professional lawyer is an autonomous person. They're there because of their independence. They have an external professional body that's very powerful and that explains their professional rules. And we understand what that is, and we can talk about officer of the court, we can talk about social contract, the monopoly that society gives people, and the obligations, fiduciary obligations in return, etc. The study of organizational professional conflict came because there was recognition that increasingly a lot of professionals are employed. In-house counsel are obviously employed, but for a lot of professionals, engineers, etc., the vast majority are employed. And there's an inherent conflict there, or contradiction, because as soon as you become an employee, you obviously owe not only a duty to your external body, but you also owe a duty to your internal, your employer. And the theory that lots of academics across the board developed was that this would create an inherent conflict and a lot of problems for individual professionals when they were trying to resolve decisions. And so a number of us looked for this great angst across the professions, and there were some people who studied this in accounting in particular initially, and then I did some work with some other people looking at in-house counsel. And to all of our great surprise, the professionals involved seemed to be able to manage their jobs without knowing much about what we were talking about. In other words, they didn't seem to identify great angst. They didn't seem to observe and practice in their world the kind of conflicts that we were thinking they must. So that led to lot of soul searching about why that was. And in fact, it was kind of funny. I was working with my co-author, and every so often we'd come back and after this and say, why is that? And there are a number of explanations. I mean, it may simply be that an in-house counsel doesn't experience much conflict because they're just really good at managing it. They're true professionals. They can sort of finesse the issues. There are some less benign explanations. Maybe they just give in to the employer, I don't mean give in, but do what the employer wants. So they finesse it that way. There are some other ones, such as maybe the firm always avoids them when they know there's something dodgy coming up. And there was some evidence of that because there was a fashion for a number of years of firms hiring very junior people to be in-house counsel. And if you're very junior, it's very hard to stand up to people, and maybe they just avoid you and never even ask you the question in the first place. So we pondered a lot about what this might mean, and in the end did a big study of in-house counsel, large number of people, and I'm just going to give you a quick overview of what it was that we found, because this ties into the theme of the world we're in shaping how we reach decisions. So when we looked at in-house counsel and how they managed ethical dilemmas, what we found, and this is one specific finding, and I'll give it to you first and then I'll explain it in more detail. What we found was the more general counsel or in-house counsel were involved in the top management decisions of the corporation, and the more they saw the real rewards of the organization going there, and they wanted to be a part of that, and they saw they could be, there was a path for them to get to that place, the more they tended to resolve an ethical dilemma as a manager would than as a lawyer would. Okay, so let me explain that a bit more. I'm the general counsel. I'm part of the strategic team, top strategic team of the organization. And there's a lot of people who would say that's quite correct, and I would be one of them. I should be. I also see that this is where all the power is and where the money is in the organization, and that's pretty obvious that's likely to be the case. But it's also the kind of organization where I could actually transition into a role in that group, not just as lawyer, but as manager. So I could be one of the players. And I want to be one of the players. And we know that there are a lot of corporate counsel that go into the corporate counsel profession, at least a quarter, who will say their goal is actually to be a manager, not to be general counsel in the long run. So the more all those conditions pertain, the more I'm going to resolve an ethical dilemma as a manager would, rather than as a lawyer would. Now, I want to make it clear, there's nothing illegal here. I would never ask people, would you do something illegal? It would be a waste of time. They're smart people that say no. We had ethical dilemmas that corporate counsel had given us. They were very realistic. They were deemed to be realistic. And we were analyzing them in terms of how people would resolve those dilemmas. And on a continuum, we were finding people to be more lawyer-like or more organizational managerial-like, because we were looking at them across a number of dimensions. And when they were more managerial-like, they tended to resolve dilemmas more as a manager would. So what are the implications of this? Well, a useful beginning point for this is to consider this from the perspective of what a lot of the sociologists of the professions would look at, and that is identity theory or identities. And we all have identities. We have a range of identities, depending on what role we happen to be in, whether we're an identity as a lawyer, as a parent, as a student, whatever. Now as pontificating academic, okay? Right, this moment, don't ask me what last night's hockey scores are, because that's my identity as a sports nut. So at any given time, one identity is particularly important to us. It's what's called salient to us. That's how we really are identifying ourselves at this time, and that identity influences how we reach decisions, how we behave. So what we were arguing when we looked at our people was that as people, under certain conditions, certain in-house counsel are going to start identifying themselves more as managers, as lawyers. Now, I don't want to go into all the implications of that, but I'll just give you one example of how identities might shape, and this sort of ties into the previous session in terms of this. The classic example, we all go back to Enron, and what people, it was alluded to in the last session, the thing about Enron was it was the absolute poster child for good ethical governance. It had a code of ethics that there were academics across North America who used for teaching purposes. It was beautiful. It had a hiring practice that was unusual. It hired the best and the brightest from whatever institution, whatever university. It did not just go to the top brand universities, business schools. They said, we don't care, we want the best. And it preached leadership and teamwork and all the good stuff. And then what it did was it placed everybody, lawyers included, into an absolute hothouse of incredible competition, cutthroat competition, with extraordinarily large rewards going to the people who succeeded, to the point that every 6 months they had the rank and yank and the bottom 10% left. And everybody knew who the bottom 10% were. They disappeared every 6 months. So you can imagine, once you start doing that, it doesn't matter how good your code of ethics is, you know what the behavior is going to be because you're told what it takes to succeed. In terms of, so those are the kinds of things that can shape our identity. It's always difficult to unravel whether people who are so inclined move to particular organizations because it matches their personal interests, or whether organizations create identities. But there's no doubt that under the right conditions, the organizational pressures can mold how decision happens. So what can be done about these things? Well, I think the most important thing, and probably the most obvious, is simply to understand the potential of what organizations can do. And it seems so incredibly obvious. Why doesn't everyone do it? Well, I'll give you an example. The most basic question that a lawyer always has to ask is, who is my client? It's relatively easy in private practice. But when you're an in-house counsel, you know, the everyday practice is whoever's bringing me the work. But of course, that's not who your client is. It's the organization, it's the owners of that organization, etc. Who is your client? Stuff we've been talking about in the last session. And the problem is, it's very easy to confuse those issues. And I'll tell you how easy it is. We've just completed a major study of lawyers in private practice in Canada. So I told you it's easy when you're in private practice to know who your client is. We presented them with a dilemma that we were given by lawyers. So it was a realistic, real-life dilemma. And it involved the issue of elevating, which you have the problem if you're in-house counsel. If you confuse the CEO with the client, you know that you have to elevate the issue. You can't simply do what the CEO wants. You have to elevate, and if need be, you have to remove yourself. This was a similar issue, but in a private practice context. The most interesting thing I found was just how difficult these people found resolving it. And this was a qualitative study, so I sat there and watched them trying to agonize their way through this, and it was a relatively straightforward dilemma with some reasonably, I thought, obvious signaling issues. But relatively few of them understood the need to elevate, and that was the key issue. And it tended to be the people who were older, who were more experienced, and who clearly, by other answers in the study that we did, had the self-confidence, the ability to say, it doesn't matter what the person putting the pressure on me is asking, I still have to do what I need to do. I understand who the client is. The most important message that I think would come out of what I've been studying for in-house counsel is very basic, and that is, whatever you do, never forget that the only reason you're there is because you're a lawyer. Okay? Doesn't mean that you shouldn't be attuned to the business. You've got to understand the business. You've got to act responsibly. You've got to act quickly. You've got to do all the things that people are taught to do in order to be good service providers. But fundamentally, if you fail to understand that your only added value to the organization is as a lawyer, then you are at grave risk of coming to grief. Certainly, many lawyers will want to become managers, and that's a good thing too. We were talking last night about how that's an increasing trend in the US to see lawyers amongst CEOs and senior managers of organizations. But I would argue that when you do that, you stop being a lawyer, because you cannot retain that autonomy, that independence. And it's interesting, when you talk to CEOs, uniformly, they will tell you the value a lawyer provides to the organization is their independence. They're really the only person who will, when push comes to shove, look them in the eyes and tell them no. I mean, the CEO is going to be mad. I'm not going to suggest they're going to love them at the time they do it. The average corporate counsel, general counsel, will tell you they have to do it once or twice perhaps in their career. But they understand, the CEO knows that's their role, and sometimes you hear the term conscience of the firm. So if you want to become a manager, but don't mix up your roles. Maintain that distinction, and you will have a lot easier time making good ethical decisions in the organization.
I think my PowerPoint's come. Oh, here it is. Good morning. I'm going to talk today a little bit about behavioral legal ethics and how that can provide some insight into the mistakes that corporate counsel makes, and some of these things tie to things that Sally has been talking about this morning, and also sort of the lessons that can come from that and how we can improve corporate counsel's decision making. So I want to start with just the question about what guides and motivates, influences corporate counsel's legal advice. A lot of the books that I have on the screen here are books that kind of study behavioral sciences and the behavioral factors that can play into attorneys' decision making. But right there in the middle, I also have a legal ethics book, because that's part of the discussion here too. So if corporate counsel is asked to give advice about a course of conduct that the attorney thinks may have criminal liability or may have liability, civil or criminal, because it's fraudulent conduct, how should the attorney advise in that situation? Of course, the client is not going to say this may be fraudulent or criminal. We're not going to use those labels. And it's going to be described as an opportunity and something that may be profitable for the company. So what advice should a competent lawyer provide in that situation? And beyond that question, what are the factors that might influence that advice? And that's where behavioral science comes in, and I'll talk about that a little bit today. So I want to start with an example, and I'll kind of come back to this example throughout the day. The person on the right is Scott Tucker, and Scott Tucker sort of gained his fame as a race car driver, but he gained his fortune in the payday loan business. So he was making short-term loans to people who otherwise couldn't, get credit, and he was often charging them between 400 and 700% interest. So some big loans. It was a $2 billion business. The fellow on the right, or on the left, is his attorney. Timothy Muir was his in-house counsel, and I think Sally mentioned this earlier today. He was hired only 2 years out of law school to be general counsel for the payday loan corporation that Scott Tucker owned. He later left, and part of the time in question that we're going to talk about today, he was also in an outside firm. So I'm talking about corporate counsel generally, both in-house corporate counsel and outside corporate counsel. And corporate can also mean any kind of organizational client. So I'm interested in representing organizational clients generally. So I mentioned the high interest rate. That probably sounds illegal to you, in violation of your usury law. And at some point, Scott Tucker and his company was getting so many complaints from consumers about these high interest rates. and states were getting interested, regulatory agencies are getting interested, and so they come up with a plan, and nobody said it's a fraudulent plan. It was just a plan that they would sell an interest to some Indian tribes. 3 different Indian tribes became the target, and they would come up with a relationship with these tribes that would make the tribes look like they were the owners of the payday loan business, and it would also make the tribes look like they were operating the payday loan business, so that the sovereignty of the tribe would make the owner of the payday loan business would make state usury law inapplicable. So this would be a defense and litigation against them and prosecutions against them, that the usury law that they were being charged with violating did not actually apply. These tribes were not actually owning or operating the businesses at times. Well, I'll get into some of the details later, but often the involvement they had was pushing a button on a reservation to approve a series of loans that were made over the day. Definitely some form over substance things were happening in an effort to make a connection between these tribes. And Muir helped accomplish that, and we'll talk about some of the things that he did today. So, a little bit about behavioral legal ethics. This is a phrase that we've only started to use recently, and it's becoming a field of study because we're recognizing that legal ethics gives us just part of the information that we need to know to understand how attorneys make decisions in practice. So the legal ethics piece is the traditional study. What are the rules, the ethics rules, what are the legal principles like fiduciary duty that guide an attorney's decision making? And then behavioral science adds another aspect to the inquiry. What are the heuristics, the biases, the situational pressures that might cause a lawyer unconsciously? Some of the decision making is fully conscious. Sometimes it's a lack of awareness of the correct legal principles that should be guiding the behavior. But how do all these things combine and help us understand a lawyer's decision making process as the lawyer gives advice to a client? So I'm going to talk about some of the legal issues, and this is for the students in the audience. The legal ethics piece still is incredibly important. We can't neglect that, so you can't start ignoring your professional responsibility class taught by people on each side of me, because we have to understand the legal obligations of an attorney, but the behavioral piece can help us understand how even a good-intentioned person might make bad decisions. And it's easy for us to call those people bad apples, but when we really look at these individuals, we often find out they thought they were doing the right thing, but some of these other things influenced them to make poor decisions. So I'm going to start with fiduciary duty. We know the attorney-client relationship is a fiduciary one, so it means that the attorney owes the client, and sometimes we may not understand who the client is, or we may be confused about who the client is, even though we shouldn't be. But the client owes duties of care and loyalty, or the attorney owes duties of loyalty and care to the client. And the statement on the screen is the duty of care. What do we expect of a lawyer representing a client? We expect, and the lawyer will have malpractice liability if the lawyer doesn't exercise the competence and diligence normally exercised by lawyers under similar circumstances. And I'm going to start with what I think is not a controversial statement, that when a client comes to a lawyer and the lawyer has some concern that the client is suggesting conduct that's fraudulent or criminal, that the lawyer should be able to recognize that there's potential liability for that conduct and talk to the client about that potential liability, so the client understands and can make a decision not to engage in serious misconduct, even if it does appear to be profitable in the short term. The issue is a little more complicated for organizational clients, and Sally talked about this today too. For an organizational client, the person we're interacting with is just one voice of the company, so we have an obligation to take concerns to higher authorities within the company so the ultimate decision maker can choose to do something that doesn't create substantial liability for the company. A lawyer in this situation also has some risk involved, because the lawyer who is advising about and furthering conduct that might be fraudulent and criminal can himself or herself face civil liability and criminal liability for participating in the conduct. So in this way, the client and the attorney's interests are aligned. It is in both of their interests to understand when conduct is criminal or fraudulent, so that they can make a choice not to engage in that conduct. So this is former Mayor Brown attorney Joseph Collins. Collins faced criminal prosecution in 2010 for the role he played in his corporate client's fraud. His client was Refco. And at the time that I was studying Collins' prosecution, I was writing an article about zealous advocacy and how corporate attorneys can sometimes misconstrue the concept of zealous advocacy and use it in ways that are harmful to their own client. And I was reading the transcript of Collins' testimony. He testified in his criminal trial. He was actually retried, and this is testimony from his first trial. He said, "I have a duty to represent my client zealously," during his testimony. And of course, that felt like a gift to a young law professor who was writing about zealous advocacy, but wasn't surprising to me at all. I think that he truly viewed his role as he was approached about doing these loan transactions that were hiding millions of dollars of debt from lenders and shareholders. He really didn't ask questions because he felt like it was his job not to understand the purpose, but to zealously advocate for doing these deals that his client very much wanted to do. The result for his client was bankruptcy. He went to prison. A number of the executives in the company went to prison. And I think it's just a great example of how zealous advocacy is a mismatch for the corporate lawyer. If you are zealously advocating for whatever harebrained scheme the client comes to you with, you're not doing your most important job, which is making judgments about things that are going to create liability for the company. Unlike litigators, as I mentioned before, the corporate lawyer is participating in these schemes and can face consequences for it. And of course, that was the case for Collins, and not to give away the ending, but it's also the consequence for Muir in the case that we're talking about, the attorney in that case. So he was participating in this fraud, and he was filing affidavits that were false with courts about the role that the tribes were playing in these transactions. At one point, he needed a backdated certificate of merger for the merger between the so-called merger between the tribe and the Payday Loan Corporation. And so at one point, he cooked up this scheme that would get himself this backdated merger document, and he bragged to Tucker, his boss, in an email in which he said, "This should be the sexual chocolate of my legal career." And anybody that was sleeping just woke up. So I'm going to read it again. "This should be the sexual chocolate of my legal career. I should just drop the mic and walk off the stage." And this email would later become relevant in the criminal trials of both Tucker and his general counsel. So I don't think we need behavioral science to understand this part. I think that the use of zealous advocacy in this setting is a conscious misconception about what the attorney advisor's role is, and it doesn't do anything that's helpful for these clients in these situations. I'm going to move on to some behavioral ethics concepts, though. A lot of you have probably heard about Stanley Milgram's experiments about obedience and how the subjects of these experiments would shock the learner in the experiment to this high level because they were being told to do so by somebody wearing a white lab coat who was an authority figure. And a far larger number of people shocked the learner to the highest level in the experiment Actually, 63% went all the way to the highest level of shock in the experiment. And what I think is most interesting about those experiments were the question to people to predict their own conduct and the conduct of others when they were put in that role of deciding whether to give a shock at the direction of an authority figure. And most people predicted that only 1 in 1,000 people would do that all the way to the end, and no one believed that they themselves would do it. So there's just a mismatch between the influence that we think authority figures have over our engagement in wrongful conduct. Solomon Asch did some experiments before Milgram's, and I'm representing this with this figure. He would ask a group of people, one was the subject of the experiment and the others were participants, to identify which line on the right matched the line on the left. And for 18 rounds, this group of people would be asked this question, and for the first few rounds, the other participants would pick the correct line, which is, of course, B is the one that is most similar to X. For 12 other rounds, they would pick the wrong line. And I mean, this is a low stakes exercise, you would think, and you probably think yourself that you would not feel any tension to follow the crowd if they picked A, even though you know that B is the right answer. But in fact, of 123 people studied, 37% of the time, people would pick the wrong line just to go along with the crowd because of the incredible conformity pressure that they felt. And if you Google this, I don't have time to show this video today, but just to watch people do this experiment and the tension that they feel to pick the wrong line, it makes you realize how powerful conformity is. I think for an attorney in the general counsel's office of a corporation, you have to think about the power of conformity and obedience pressure. At the time that Muir took this job, he was 2 years out of law school. And he said he followed the lead of other attorneys before him. He operated in good faith, believing that his actions met the legal standard of the industry. So I think that this is something that attorneys have to think about. I know I'm running out of time. Another issue is partisan bias. Anybody that's watched a football game with teams from the other side knows that we see things in different ways depending on who we're rooting for and who we're partisans of. And from 1954, there was a study of fans from Dartmouth and Princeton who were asked to view videos of football games between the teams, and unsurprisingly, as they were asked to decide whether a penalty was flagrant or mild and decide who initiated it, they saw things very differently. And there have been consistent studies through the years that show, accountants who are told to imagine that they either represent the company or a prospective purchaser as auditor of files are going to come up with very different results depending on whether they were asked just to imagine hypothetically that they're representing the purchaser versus representing the company. And in a study that will hit close to home for the law students who are given hypothetical case files evaluate their own clients' claims more as stronger than that of the opponent. And I think that's always true for my students too. Partisan bias can be a really good thing in advocacy in the courtroom, but it can be a very dangerous thing for a corporate lawyer who maybe doesn't realize that the client is not the person who is advocating for a course of conduct, and they want to try to find a way to argue that something is legal even though they have serious questions about it. In the interest of time, I think I'm going to skip this right now, but I want to talk a little bit about confirmation bias. And if you have time to look for this video on your own, I hope you will. Confirmation bias describes our bias towards seeking evidence that will confirm our beliefs rather than testing our beliefs. And if you look for the Wasson Rule discovery test, you will see that time and time again, people most often test their theories by trying not to come up with a counter to what they think their theory is in order to test it, but rather find confirming information to find a way to make their theory work. And I think we see general counsel and corporate counsel do that too, try to find a way to maybe justify that a course of conduct is perhaps legal rather than trying to think like a prosecutor. As we know, John was in that role, which I think would be such a great benefit to corporate counsel, to be able to think like a prosecutor and think about how might a prosecutor see these series of facts. So I want to talk about consequences in the case of Tucker and his payday loan companies. The FTC obtained their largest civil judgment to date in the case against Tucker and AMG Services, which is the name of his larger umbrella corporation for his payday loan company. The judgment against them was for $1.3 billion for illegally charging consumers undisclosed and inflated fees. And beyond that, Tucker and his attorney, Muir, were both prosecuted. Tucker and Muir were convicted of 14 fraud-related counts. Tucker will spend the next 16 plus years in prison if his sentence is affirmed on appeal. And the attorney, and I know attorneys sometimes think we aren't subject to criminal prosecution for our role, but of course we are and we can be. Tucker, this is his prison that I've pictured here. It's Moshannon Valley Correction Center in Pennsylvania, and he was sentenced to 7 years in prison for the role he played in the payday frauds or payday loan scheme. So a little bit about solutions. Coffee is always a solution to me, but there are a number of solutions that I'm exploring in this article, but one that I'm especially interested in talking about and having you all think about too is priming. Would you think that the addition of these eyes above the coffee in your office would make you more likely to put some money into the contribution tin? And the answer to that has been yes. So in one study where just a pair of eyes and no words or explanation were placed above the coffee in alternating weeks, and the other weeks just some pictures of flowers were put there, is a remarkable difference in the number of people who pay because those watchful eyes have primed them to do so. So I've been really interested in that and other priming studies and thinking about how we might be able to prime general counsel, other corporate attorneys to provide better advice to their clients about criminal and fraudulent conduct. And with that, I really encourage you, if you think of ideas for me about priming or anything else, to reach out to me. I'm interested in hearing your questions today. Thanks.
So I speak from the trenches. I'm a general counsel of a public company here in Northeast Ohio, Diebold Nixdorf. It's been around for over 100 years. We have 24,000 employees around the world, about $5 billion in revenue. But I certainly didn't start here, and I think I violently agree with the comments from Sally and Paula about the tension that in-house attorneys face. But I don't necessarily think of the title of this panel is the tension between corporate goals and giving impartial legal advice as an in-house attorney. And I don't necessarily see that as mutually exclusive. And I'm not surprised, actually, that Sally learned as she talked to in-house counsel that typically people don't feel that they're in these incredibly tense positions. Because I think that most attorneys, I think good attorneys, find a way to play the role and feel like they're playing the role and manage the conflicts that are presented to them. The key feature, of course, being remembering the role you're playing. I think what matters for in-house lawyers and what defines a good in-house lawyer is who you are as a lawyer. And that is colored by your training, by your personal ethics, by your conviction, by your understanding of what a lawyer does and why it's special. And so I just wanted to share with you today a little bit about my story and how I unexpectedly landed in the seat of a public company general counsel, which I never expected, but I come from a place that's very much born out of the ideas of this panel, which is kind of ethics and doing the right thing. It started for me, I mean, I teach at this law school as an adjunct. My class that I teach is white collar crime. And I always ask the students at the beginning of the course to think about why they went to law school, and I posit to them somewhere in there was a sense that the law is about right and wrong. There's something romantic that brings us all to law school. Even the most cynical of us go to law school for some reason connected to right and wrong. And we may lose that sense over time as we become jaded through the real world. But somewhere in there is that sense. And for me, that led me at the beginning of my career to become a prosecutor. And I want to share a little bit about that with you. And then as I continued in my career as a prosecutor, to look at going through the looking glass to kind of the other side of the world. As a prosecutor, I was constantly, I worked in the Southern District of New York. We did a lot of corporate fraud cases. And I was constantly looking at the other side of corporate America and asking the question, how bad is it really? It feels very black and white from this side. How bad is it? And is there something good that can be done by going through the looking glass? And years later, here I am as a public company GC. So let me just share with you a little bit about how my story was colored and encourage those of you who are students to think about this and to think about going in-house, because it truly is on the other side of the looking glass, right in the trenches where you can actually make real impact on not only a business, but on thousands of people's lives through the decisions that you make. So I included this quote from Through the Looking Glass, and I won't dwell on it other than to say it's a great quote because Alice goes through the mirror and observes that at first, everything on the other side looks very similar to the way it looked looking through the mirror. But as she looked closer, she realized things were very, very different. And to me, that's kind of been the journey of my career, and I would suggest anyone who wants to go in-house should try to pursue that kind of journey as you get ready to make the kinds of decisions you have to make. So I started shortly after my career began. I became a prosecutor in the Southern District of New York. This is me as a little baby prosecutor, my first day, and one of my great heroes in the law is Mary Jo White, who was the U.S. Attorney in New York. I always struggle with this picture because she was so good at saluting, and you can see that I had never saluted before in that way and had to figure out how to mirror her. But as a prosecutor, particularly in this office, we were taught and reminded that the law really is all about right and wrong, and that what we were there to do is to punish those who had done horrible things, the worst kinds of things that we can imagine in our society, and take away their liberty. And for me, it was terrific training for kind of what it means to be a lawyer. This is a picture of the office, the U.S. Attorney's office in my first year there. And I keep this picture on my desk and look at the faces of the people from that office, many of whom are shaping our world today on these very topics of right and wrong. There's people in this picture who are in the Mueller team actually doing that investigation. There's people who are federal judges. There's people who are writers for the National Review on the right, and others who are hosting podcasts explaining the law on the left. And it reminds me of all the things that I learned as a prosecutor. This is my own particular Comey memo. We've read and heard all about Comey memos when he was FBI director. Jim Comey was my second boss after Mary Jo left. And I share this only because we all in the office, in the U.S. Attorney's office, were taught to kind of believe in something bigger and in ideals and right and wrong. Jim Comey was somebody who actually taught us that and talked about that and had great conviction about it, but that doesn't mean that judgments that are made in pursuit of those goals are right or wrong. This is the game that we all play as we move through the law. This is something that when Jim was U.S. Attorney, he gave to all of us who were prosecutors working for him, and it's kind of a recitation, and I also keep this on my desk, about what it means to be an AUSA in the Southern District of New York and the ideals that you're supposed to pursue in pursuing right and wrong in your work. I left the government and went into private practice and kind of moved halfway through the looking glass, if you will, to start defending people and companies all over the world. And for 10 years, I worked at Jones Day, where I got to see corporations from the outside and look at boards of directors and how they behaved. And I was very interested in the panel this morning and some of the criticisms we have of our system of board of directors. And I think those criticisms are fair in many ways, but I also think my personal experience as an outside lawyer advising boards is that the process, in my experience, does work quite well when you get into a boardroom. Most directors that I've advised, and I've advised many boards of some of the biggest companies in the world, really do take their duties extremely seriously and work very hard to pursue those duties as they are laid out for them under the law. And so I got to see how corporations deal with ethical issues from the outside, but I always felt a little removed. I felt less removed than I was as a prosecutor when I was coming at companies and people to determine whether they had violated the law. Now I was defending them. But when you're an outside lawyer, you're never quite in the game. You're always separated because the stakes are different for you than they are for your client. But I happened to encounter a particular client who kept me very busy. And that client was the Diebold Incorporated company where I now work. Diebold, as I said, is a 100-year-old company, started as the Diebold Safe and Lock Company here in Ohio. Elliot Ness was once the chairman of Diebold. Diebold was one of the inventors of the ATM. And it's a great old Northeast Ohio company that does tremendous things, not only for its customers around the world, but for thousands of employees who make their lives and careers at the company. Well, Diebold stumbled, not once, but twice, in ethical and legal ways. And that's how I got to know the company. First, I represented the company in what was, for us here in Northeast Ohio, a pretty massive securities fraud. And the company, it was a mini Enron, and the company was involved in improper accounting practices. As outside lawyer, it was my job to conduct an internal investigation to unearth those practices. We cooperated with the Department of Justice and the SEC. The company settled those charges for $25 million in a fine with the SEC. And on the heels of that case, we discovered that the company had also made some payments which violated the Foreign Corrupt Practices Act. And the company had the very difficult decision to make, an ethical decision, and I was outside counsel, whether to self-report this set of bad facts that we had found. And that's an incredibly difficult decision for a company and a board of directors. And I will say, being in that room, and of course this is all public now, that the board of directors really wanted to do the right thing. And this was a group of people who evaluated the facts, looked at the circumstances, and decided to self-report, even though the company had just completed this accounting fraud investigation. And so, several years later, the company settled yet another criminal and regulatory problem with the DOJ and SEC dealing with foreign bribery. And it was at this point that my life and career changed, because the board of directors decided no more. This company cannot afford another problem. and asked me to come aboard as general counsel to revamp the global compliance program, to build a team of lawyers who were skilled in grappling with these exact type of issues that we're talking about on this panel. People who would understand exactly that their roles in the company were to be lawyers and to make sure that the corporation behaved ethically and legally. And so for the past several years, we've been building what we believe and are proud to feel is a world-class global compliance program. But while we did that, there were many, many, many business issues that we had to grapple with along the way, including, and not only did I have to deal with those issues, but as general counsel, this is just an example of the many types of legal issues I face. I have to deal with governance issues with our board of directors, commercial contract issues, intellectual property issues, all the kinds of legal issues that face the company. But in the middle of all that, the company decided to double its size and go out and acquire one of our biggest competitors in the world, a German company called Wincor Nixdorf. And so we were in the process of building this global compliance program and dealing with a DOJ and SEC monitor who was watching us to see whether we were behaving ethically while we were engaged in a massive M&A project to double the size of the company, which was very important to the business. And we had to balance business issues and legal issues constantly throughout that several-year process, but ended up completing our FCPA monitorship on time, getting a sign-off from the DOJ and SEC that our compliance program was up to snuff, and completing our acquisition of this big German company. And I would say every day we had to face the kinds of issues that we're talking about on this panel and remember exactly what our role was. And so now I am through the looking glass and on the other side, and I can say I'm very proud to have done it, to kind of jumped into the trenches and to do it. And I don't see this dichotomy between kind of doing the right thing and promoting the company's interests as one that can't be resolved as long as you truly do remember what your role is. I look forward to talking through some issues with you all today.
Great, thank you all so much. I want to open it up to questions from the audience in just a minute. But before we do that, I have a question for the three of you, any or all of you, which is one of the things that we're starting to see more and more is an emphasis on whistleblowing, either internal whistleblowing, which can look a lot like the lawyer's duty of up-the-chain reporting, and potentially also external whistleblowing, and to the extent that it is appropriate or inappropriate for attorneys to serve as external whistleblowers. Of course, this is something that the model rules have struggled with, and that states have taken different positions on. So I was wondering if any or all of you could speak to some of those issues.
I've written a little bit about that issue, and I think that it can feel confusing to an attorney to think that being a whistleblower can be loyal to the company. But I wasn't the first person to coin this phrase, but another professor calls this loyal disclosure, and I think that's exactly right, to look at the SEC rules and the ABA rules that have been adopted probably in the majority of states at this point, 1.13c, that allow an attorney who thinks that disclosing fraudulent or criminal conduct outside of the company could potentially be in the company's interest, then they should do that under those rules. And I think that even though the SEC rules only allow reporting to the SEC, those state professional conduct rules that follow 1.13c could actually allow something that could protect the company. If you could disclose information to someone who could take steps to get the company to change course, I think like a shareholder who doesn't have a seat at the table might have such an interest. And they apply to companies other than corporations too. So I think that it's something that lawyers should be thoughtful about, that there is an ability under these rules to be a whistleblower when doing so will actually protect the company. I've seen the SEC, I've seen a speaker from the SEC say before they have not received whistleblowing under their version of these rules, but they've gotten calls before about how they work. And I think that may be the most important function of the rule, is that an attorney could talk to a client about the ability to make this disclosure, and maybe that makes the client do the right thing.
Yeah, and to us, in our compliance program, reporting, whether it is by name or anonymously, is vitally important, and it's a huge component of our program. So not only do we have an anonymous hotline and we have a place you can go online, but we actively promote this to employees around the world to make clear we want to hear from people. And that creates an effect. And we get reports and claims and allegations every day. And it's part of our job. And it creates an environment where people know that the company wants to hear from them. Managers know that they're being watched by their own people. A lot of the claims that we get turn out to be nothing, but some of them turn out to be something, and we investigate every single one. And that, to me, is best practice in corporate compliance today.
I just want to follow up to that, because part of Milgram's experiments on obedience told us that the thing that made people less likely to be obedient is if they thought there was another authority figure. And what they've created is an infrastructure that creates another authority figure that's encouraging you to do something else by doing this reporting. And that is something that creates an ability of somebody to not engage in wrongful obedience, but to actually take a more ethical step.
Can I just add that a number of people in the room are sort of at the beginnings of your careers, and I'm always mindful for every company such as Diebold that's doing the right thing. You have to be really careful as a whistleblower. And I'll give you an example of when I assisted someone at my own university a number of years ago who was whistleblowing, and it was to a very senior level of the university, very, very senior. And the university did the right thing. You know, they did the absolute right thing, except a year later that person was gone. And it was at that point I realized, for all the appearances, and I had no understanding of what happened because there was confidentiality around that person leaving, and I heard nothing more. But there's no doubt that in many environments there are real costs. You have to be really careful with whistleblowing, and you can be very naive about how much people want to hear from you. So get good advice if you have something serious that you want to whistleblow about. Is that a fair statement?
No question.
Because ultimately, in many environments, there's no way we can protect you. I found that, and I think it was just one of those sick things when I thought I had the perfect environment for protecting. You know, the university had really done the right thing, and I couldn't protect them. And so, you know, imagine if it's much lower stakes, much more, you know, there's some very bad things that can happen to you.
Yeah, well, and that's why it matters what kind of company you work at and how much the company is committed to dealing with those kinds of issues in an appropriate, fair way, and how much the leadership supports the compliance team in handling those issues. That all matters, and it's a living, breathing thing that has to be refreshed and endorsed constantly.
Yeah, and I think sometimes when we're teaching, we just stress this as if it's so obvious that everyone will want to hear from you, and they don't always. That's the problem.
And then for those lawyers who are more senior in the organization, right, an important part of their job should be thinking about creating those organizational structures that encourage ethical behavior from those below and create a situation where, you know, if somebody does have an internal complaint and engages in internal whistleblowing, that there are protections in place. Yeah, that's a tough one. Questions from the audience?
So for Jonathan, so when you worked for Diebold, what was it, how did it evolve? How did it come to pass that a company that had experienced and had been involved in serious, criminal conduct, what caused them to say, okay, now we want to do the right thing? Was it an individual? Was it a board? Was it you? How did that happen when it did not happen for other companies such as Enron and other corporations?
Yeah, well, I mean, look, for a company like Enron, it was the end of the company. I mean, the fraud was so endemic that there was nothing left. The good news for most companies, I would say, that have these type of issues is that there's something else that's good. At Diebold, I've always thought of, even when I was outside counsel, as kind of a little engine that could, where there was a lot left that was really good about the company. The way that the company served its customers, the way that the company provided careers to its employees. There was something left to save. And the board really did handle these issues the right way. From the minute that the board learned about these issues, the board investigated them, remediated them. Then when another issue came up, self-reported, knowing that that could lead to who knows what consequences, and the consequences were onerous. But I would say it was a learning process for the board. I mean, this was not a single light bulb moment where the board decided, okay, we're going to fix this. This was a period of 10 years where problems continued to come up and the board continued to learn how to deal with those problems, ultimately saying, we need to hire a former federal prosecutor to rebuild our entire global compliance program and show that commitment, which is what ultimately allowed the DOJ and SEC to say, you're good, you've done the right thing. Companies are like people. They learn, they're organisms, they're alive. And some are better at this than others. I'm fortunate to work at a place that went through kind of this crucible and came out on the other side. But a lot of my former clients struggled with this in a lot of more gray areas.
I also have one for Jonathan, which is, when you guys are doing compliance, how do you measure it? Is it just the absence of incidents or events, or do you have metrics that you guys use to compare yourselves to other firms? And are those metrics something you can share with us?
So we do some benchmarking. There's a lot of organizations out there and we share information with other companies and their compliance programs that kind of benchmark for your size, how many complaints should you see if you're really running an active whistleblower platform. And we certainly do that kind of benchmarking. One thing that we have struggled with, and this is a struggle for all, I think, businesses, is how do you reward ethical behavior? Because we've communicated to our employees that they will be rewarded and moved up the chain and viewed as better employees if they act ethically. It's not just pure table stakes that is kind of a minimum requirement. It's actually something that will allow them to advance. But how we measure that is through individual reviews. So we ask our managers and supervisors to review how ethically did their people behave. We haven't come up with that kind of mathematical metric for that yet. It's a struggle.
Yeah, I think we have a question from the panel.
My question is, you've just taken, well, not maybe just, I'm not quite sure, when you took over a German company, and of course immediately I think of Siemens and I think of VW, I think that's a huge cultural difference. How did your compliance program work with a takeover situation?
Yeah, well, Diebold is in 120 countries around the world, and cultural issues are enormous. Translating our ethical norms from here in America, where we've been through Enron and WorldCom and Martha Stewart and all these big frauds, to places Germany has had its own share, but culturally they approach compliance in a different way. And I'll give you a big example of a cultural difference. is here in the United States, public companies receive requests from the government all the time, subpoenas, requests for information, and we are very used to immediate compliance and cooperation with a government request. Well, in Europe, actually the focus, and this has become much bigger with this recent law called GDPR, the immediate focus in Europe is on data privacy of people. So when a government request comes in for information from Europe, while in America our first inclination is give the government anything it's requested, the perfectly ethical but very different response in Europe is, wait a second, we owe a responsibility to our employees about all the information that we store for them. And that's just one example of dozens that we've had to grapple with as we doubled our size, with now half of our colleagues around the world come from Germany. It's a very difficult issue, yes.
Sort of, George, just a comment that is skeptical about compliance. So there's been a huge growth in compliance. I don't know if anybody's tracked the actual figures, but just some anecdotes. In 1999, Fidelity had 1 person in their compliance department. They have 700 now. JP Morgan in 2015 hired 8,000 compliance professionals, bringing the total to 25,000. All these people are not adding to economic growth. They're just making sure that people are doing which is important. But I think there's a question asked about compliance, which is a dollar spent on compliance actually giving us $1 in reduction in some way that's more than $1 or more in fraud avoided or something like that? And I'm skeptical that that's the case, because I don't think Fidelity is that much safer today than it was then when they had 800 people, or JP Morgan is that, the shareholders and consumers and employees of JP Morgan are that much better off. And I just wonder what the constraints are on compliance, because I think, to Sean's point about metrics, businesses are probably reluctant to skimp on compliance, especially when the Justice Department comes and says, when you get in trouble, which you will, you're going to get a lot of credit from the Justice Department if you've had a robust compliance department and spent a bunch of money. So it's just something to think about, is like, what is the constraint on people spending money on compliance? I doubt your CEO pressures you to really reduce it to be its most efficient. Maybe they do. But there's been a huge growth in compliance, and as a social matter, I just wonder whether we're getting what we're paying for.
Yeah, it's a great point, and actually, it's not a subtle point for us at all. It's one that we grapple with every day. I mean, the fundamental concept is that good compliance is good business, but striking that right level is critical, and we take that very seriously as leaders, as managers, not as lawyers, where we talk to our board, we talk to our leadership team, our CFO, about how much should we spend? How much money should we spend on this? And how much are we adding to the general health of the business? Our feeling is we are, but there is a tipping point. I believe, my personal belief is that there's so much risk to businesses around the world today that you have to invest in this culturally and to ingrain it in your business, but you also have to never lose sight of the general business proposition that you're there to make money, and you have to have an ROI.
Great. I think we're running out of time now for this panel, but I've been asked to let you all know that there are boxed lunches out front. And the plan is for everybody to grab a box lunch and bring it back here in 15 minutes. We will have our keynote address starting at noon. So go ahead and pick up a lunch, and thank you so much to my panelists.